The market capitalization of the coin is used to summarize all that is taught in this video. I would also like to remind you to give my channel a like and subscribe to it so that you can stay up to date on future XRP news as well as other cryptocurrency news in general. Take a look at this now, shall we? The XR programmatic sales verdict is likely to be appealed by 1 second now. Ripple is currently engaged in a legal battle before we move on. There is a brand new cryptocurrency airdrop that is now taking place, and it is about to begin very shortly. Participate in this conversation on Telegram, and please take your time doing so. Within the video's description is where you will find the link. Alright, let's go with our video. Reports indicate that a former attorney for the Securities and Exchange Commission is fairly hopeful about the possibility that the agency will submit an appeal of the ruling regarding the 2023 programmatic sales of XRP in the Ripple litigation. Attorney Jeremy Hogan has requested the Securities and Exchange Commission SEC to assess whether or not the appeal is pertinent to the advancement of the SEC's mission. According to recent speculations, the United States Securities and Exchange Commission SEC may not be satisfied with the verdict that was handed down in 2023. This might result in an unexpected turn of events in the ongoing legal battle between the SEC and Ripple Lab, which has been going on for a number of years. According to a journalist for Fox Business named Eleanor Tarrant, a former attorney for the Securities and Exchange Commission is adamant that the commission will most likely challenge the decision, particularly with regard to the XRP programmatic sales of goods and services. According to a former attorney for the Securities and Exchange Commission SEC, the SEC will most certainly file an appeal against the ruling that Judge Torres issued in July 2023 concerning the XRP programmatic sales in the Ripple case. This is due in part to the fact that everyone in the SEC sincerely believes that the decision is correct. The 26th of September 2024, Eleanor Tarrant. To put things into perspective about the situation, Ripple Labs was held liable by the Securities and Exchange Commission SEC in December of 2020 for allegedly offering investors unregistered securities. In July of 2023, Judge Elisa Torre came to the conclusion that Ripple did not violate any regulations when it offered XRP to normal investors through market exchanges using a programmatic approach. The fact that 1,278 instances of direct sales of the asset to institutional clients were in violation of federal securities legislation was brought to the attention of the audience by her. The court issued an order that the blockchain corporation pay a total of $125 million in civil penalties as a consequence of the incident. A request for a stay on the monetary portion of the recent ruling was submitted by Ripple to the United States District Court for the Southern District of New York on September 4th. It was stated by Ripple in the filing, which we went into great detail about, that the SEC had agreed to postpone the payment beyond the deadline of September 6th. As an additional suggestion, the company proposed that the bank account be funded with 111% of the total judgment amount, which was $139 million. It is essential to keep in mind that the funds would remain at that location for a period of 30 days. Following the conclusion of the appeals session, this is the case. Conjectures concerning appeals, a number of rumors appeared before to the deadline for appeals on October 7th, and experts evaluated the likelihood of each of these reports. The attorney Fred Rispoli, who is in favor of XRP and believes that the prospects are greater now due to the current intricacy of the case, is one of the individuals involved. Putting that much money into a trust is not something that happens unless the SEC refuses to tell the lawyers representing Ripple whether or not it intends to pursue an appeal. This is despite the fact that there is no guarantee that an appeal will be filed. It is still possible that no appeal will be filed, despite the fact that the possibility of this happening has increased. Ripple's chief legal officer, Durate Aldarati, recently announced that the 4-year dispute was over. Attorney Jeremy Hogan refers to this when he says that the SEC has lost the plot and that the organization's choice to file for appeal should be predicated on advancing its mandate of investor protection. In the meantime, and so when the commission acknowledged that it had misrepresented XRP, Ripple's chief legal officer made this announcement. Due to the fact that they were on the losing side, it was only reasonable for them to assume that the view was misleading. At the present, the Securities and Exchange Commission ought to be thinking about whether or not an appeal contributes to the advancement of its goal of capital formation and investor protection. Do you not see that to be another evidence that the Southeastern Conference is falling behind in its game? Regarding the identity of its coin, Ripple Labs is ready to engage in a battle with the Securities and Exchange Commission SEC of the Commonwealth of Massachusetts. The outcome of the litigation that is scheduled to take place in October will determine whether or not the token is considered to be a security. Although the SEC submitted the action in December of 2020, it has not yet gotten a response that may be considered conclusive. Considering the impact that the two parties had on one another, a great number of people expressed their emotions on X, and opinions regarding whether or not the SEC would pursue the appeal continue to be divided. Stuart Aldarati, the legal officer for Ripple, stated that the AI fair notice defense continued to exist despite the fact that the lawsuit had been resolved. This prediction was made by Aldarati, who believed that Ripple would emerge victorious even if the case was taken all the way to the Supreme Court. On the other hand, retired securities attorney Mark Fagel stated that in the event that an appeal is submitted, it is not going to be heard by the Supreme Court, but rather by the Court of Appeals for the Second Circuit. In addition, he noted that it would take approximately 10 to 11 months for the decision of the Second Circuit Court of Appeals to not rule to be brought before the Supreme Court. A prior ruling by Judge Annalisa Torres stated that Ripple's automatic sale of XRP to investors did not violate any of the limits imposed by the Securities and Exchange Commission (SEC). However, she did point out that the token's institutional sales policy had been violated because of the violation. Eleanor Terrett, a journalist for Fox Business, has stated that a former attorney for the Securities and Exchange Commission believes that the SEC would most likely appeal the ruling that Judge Annalisa Torres handed down in the Ripple v. SEC litigation in July 2023. In his statement, the attorney mentioned that some of the employees at CXE are of the opinion that Ripple's programmatic XRP sales result is incorrect and ought to be challenged. This is still an important matter that needs to be monitored constantly as the case progresses. In order to file an appeal, the SEC has until October 7th to do so. Former United States Securities and Exchange Commission USEA attorney forecast XRP case in Ripple v. SEC lawsuit. The former SEC attorney said in the article that many people inside the agency continue to believe that Judge Torres made a mistake in his finding on the Ripple programmatic XRP sales. It is possible that this concept will inspire the agency to submit an appeal, particularly if they argue that the verdict does not adhere to appropriate legal standards. That the SEC may seek an appeal of this verdict is something that has been mentioned by other business insiders, and the attorney's comments are consistent with those of other individuals. Despite the fact that there is the possibility of an appeal, the United States Securities and Exchange Commission does not oppose the judge's judgment that XRP does not constitute a government security. The rhythm of the Ripple. The complaint filed by the Securities and Exchange Commission (SEC) has garnered a great deal of attention due to the fact that the SEC's appeal is anticipated to revolve around the classification of programmatic sales and the question of whether or not they satisfy the legal standards outlined in the Howey test, which is important when assessing investment contracts. Additionally, Mark Zifigel, a separate former attorney for the Securities and Exchange Commission, noted that an appeal is anticipated due to the fact that the deadline for bringing the complaint against the SEC is drawing near, has attracted the attention of a number of different notable individuals. John Detton, an attorney, has been actively involved in the case and has filed an amicus brief on behalf of XRP investors. He has provided his thoughts on the chances of the SEC winning the Ripple vs. case. As stated by Detton, the ruling that Judge Torres made with regard to programmed purchasing was extremely fact-specific and was based on the specifics of the Ripple case. He brought up the fact that although the agency might argue that secondary sales of XRP might satisfy the requirements of the Howey test in other instances, he pointed out that this is not necessarily the case. It was determined that the circumstances surrounding the case between Ripple and the SEC did not satisfy those conditions. In addition, Deaton stated that even if the case were to pass the third component of the Howey test, the United States Securities and Exchange Commission would still be required to demonstrate that a common enterprise existed. This was a significant weakness in the case. As a consequence of this, he came to the conclusion that there is a slim probability that the appeal will result in a change to the first decision, and that doing so would be both expensive and time-consuming. Earlier, Judge Torres had issued an order that required Ripple to pay a penalty of $125 million. On the other hand, the court decided to postpone the payment until the appeal result was determined. Concerned about the protection of investors in the SEC approach, in addition to other attorneys, Jeremy Hogan expressed concern over the aims of the United States Securities and Exchange Commission in the event that the agency decides to appeal the verdict. It should be noted that the material that has been supplied is not intended to serve as business advice. In the event that any investments are made on the basis of the information that is provided on this page, there is no responsibility for those investments. Prior to making any choice on investments, we strongly recommend performing independent research and talking with a professional who is educated in the field.